Hey, I'm Jonathan Miller, and this is the Housing Helix podcast. I'm a real estate appraiser, analyst, and blogger based in New York who is interested in pretty much anything related to housing with an analytical bent. The Housing Helix is the real estate conversation in long form, with information, analysis, and commentary, as well as insights from housing-related experts that have something interesting to share. This episode and the entire podcast library are available as a free subscription through iTunes and at thehousinghelix.com. I hope you enjoy it. I'm here today with Adam Leitman Bailey, who is of Adam Leitman Bailey PC, which is seems to be one of the go-to sources on real estate-related matters in the media. I've run into Adam many occasions. He's received a number of awards, which I'm going to link out to in the podcast. And he's also releasing a book next year, which I was reading your bio, and I thought that was pretty interesting since I sort of want to do that myself. But it's great to have you here, Adam.
Thank you.
I ran into you the first time I actually met you was when we were at a panel discussion with Elizabeth Stribling at
New York Law School.
New York Law School. I think it was less than a year ago. And what struck me about the interview was, first of all, you come across as and you are it was very sharp and very impassioned about what you believe is right, etc. And I said, boy, it'd be fun to have a conversation with you. And then I was reminded of my sort of you on my list to contact when in September there was an article in the Times and a lot of coverage on a ruling that we're going to talk about relating to buyer deposits. But before we do that, and my long-winded introduction, I'd love to sort of get an overview of what kind of law you practice and a little bit about your firm.
So we are a 22-attorney law firm that only practices real estate, limited to real estate. The way I did it was, if I'm not within the best at what I do in law, then we're not going to do it.
Okay.
So all of our attorneys, I believe, are among the best in their field. So we do all types of real estate law.
Is it residential and commercial?
Residential and commercial.
And is it the New York City metro area, or
we don't go anywhere where we don't at least know the judges or at least know their names. So right. So it's New York City metro, also Westchester, some Long Island, Rockland County. We have an actual office in, and we do closings in New Jersey.
Okay.
It's the only thing. We don't litigate in New Jersey, so we're limited to basically New York metro and beyond. I guess within 2 hours distance of our office.
And when did you start the firm?
In January 3rd, 2000.
Okay,
so I went on my own and put out a shingle. And although you couldn't really see the shingle because I was on the 21st floor of an office building, but it was still there.
It was a shingle in theory.
Yeah, it was a shingle. Yeah. Actually had one. I had a nameplate, but it didn't really go anywhere. But,
right. Yeah. And had you practiced real estate law before you went on your own?
Yes. So I went on my own my 6th year. So I worked at 2 smaller firms or 2 other firms.
Right.
One was called Winsig & Winsig. It was a 4-attorney real estate firm. And then I realized that the first firm that you really can't do real estate litigation without doing landlord-tenant law. So then I went to a firm called Bora Goldstein, Altschuler & Schwartz. It was then Finkelstein, Bora Goldstein, Altschuler & Schwartz, and learned landlord-tenant law, and then thought I had enough to go on my own in January of 2000.
Interesting. Do you find yourself, in terms of in litigation, do you tend to seem to represent building owners more, tenants more? I mean, is there a sort of commonality in who you represent? Are you known for that, or is it because it seems like you're across the board? But maybe
I am across the board. We're happy to represent anyone who has a good case that we like, or anyone that needs us. We don't discriminate based on the cases.
Right.
We are very ethical and have high integrity. So we're not a place that starts frivolous lawsuits, but we represent both landlords and tenants and developers and buyers and contract vendees. As long as it's real estate, we're willing to do it.
Right, and it seems like more and more you're grabbing the headlines or attention with higher profile cases. Comes to mind, just came out that you're representing the developer on the Moss site downtown.
Yes.
Against a lawsuit that was filed. But actually, what I wanted to understand,
that's probably the biggest case in New York, whether New York realizes it or not, because it's the freedom of religion.
Right.
And it's a $350 million lawsuit against the builders of the mosque, and then they're amending the complaint on the city one to stop the actual building. So as far as freedom of religion, we haven't had a big case like that in I don't know how many years.
Wow. Right. And it's interesting because it's a combination of freedom of religion, but it's real estate related as well.
Because they're building, right. In other words, well, the organized religion, most places you need a place to pray.
Right.
And the Muslim religion includes that, and they're trying to build a place to pray, and we're standing up for their rights to do that.
Interesting. Well, one of the other cases, and what I had brought up earlier was this issue which evolves around the Interstate Land Sales Full Disclosure Act, and this idea of buildings over 100 units where the buyers would be able to get their deposit back, which, given the pricing of real estate here, and the specific case mentioned in the lawsuit, the deposit was over $500,000, so it was no small amount of money. And
this isn't the only case. There's other cases going on in different courts with our firm. One of them, the person is actually a billionaire, and it's a $24.7 million purchase.
Right. Well, what was interesting is as the market changed, and we all realize that housing prices don't always go up, and markets change. It seemed like a sort of rash of attempts for buyers to get out of their deposits in new development, and it seemed to be along the line of sort of non-performance, and it's probably not the right legal term. In other words, the offering plan says that the ceilings would be 11 feet. They ended up being 2 inches shorter. I'm not getting what I want. I want my deposit.
Right. Actually, that was a common case where remember, most new construction, you're buying a dot on a map.
Yes.
So you're actually told, and you're given brochures of what you're going to see, but you don't actually know, because unlike a house that has been around for 100 years or 50 years, you could test it out. You could see the leaks or creaks or what's wrong with it or what's right with it.
You're buying like a square in the sky. Basically.
Exactly, a square in the sky, and you don't really get to see it.
Right.
So then you get to see it, and sometimes it's not what was promised.
Right.
And the laws are very limited in what contract grantees, people purchasing, can do. In fact, most of the statutes are anti-consumer. So you need a really creative and talented lawyer to navigate the waves of getting the place that was promised in the offering plan.
So in this particular case, which I'm assuming
about the one with the ceilings, we have one in front of the Court of Appeals right now.
Right.
That actually had in front of the highest court in New York, and the case is a precedent because the HVAC developer has been sued directly.
I see.
And what the HVAC developer is stating is, you can't sue me. I work for the developer, and you should sue the developer. Well, what this is sending, what the message that the Court of Appeals is either going to send or not send out is, well, what happens when a developer goes out of business?
Right.
Does that mean that the HVAC developer, who they're advertising as the best in the world in their offering plan, who creates the greatest air conditioning equipment, is he not suable? Well, then who do you sue? Who do you turn to if the developer's out of business? That case is about to was argued about a month ago in front of the Court of Appeals by our firm, and will be decided. It could be any day.
And this is different than the related case.
Yes, no, this is, it's called Sykes v. RFD Realty, et cetera, the air conditioner company, et cetera.
Gotcha. Well, in the related case, maybe you could tell me what the Interstate Land Sale Full Disclosure Act is, and how that was used in getting a successful outcome for your clients.
Well, I read a lot. I'm reading all the time. I mean, right. it's the bad thing about practicing law is you got to be on top of the law. You have to keep reading. You have to keep up with it, because you never know what you're going to find.
Sure.
And desperation breeds creativity.
Right.
And we had it. The phone was ringing off the hook. We have a closing department with 4 attorneys, and all they do is real estate closings and commercial leasing.
I see.
And we have a lot of closings in our office. We did, I believe we did 639 last year.
Wow.
Not this year, last year. Mm-hmm. And buyers had lost their jobs. They had put down payments but lost their jobs. Many others wanted to still purchase. They had jobs, but they couldn't get the mortgages anymore. The banks curtailed the amount they were lending.
Yes.
So they either were going to lose your deposit, or we needed to come up with something fantastic. We need to find something to have leverage with the developer for them to decrease their prices, meaning give them a discount off the purchase price, so they can get enough money to close, meaning that the bank would lend them enough money.
Right, they would be compliant within the lending ratios based on a lower price.
Exactly, because they appraise the value.
Reflecting the drop in the market or whatever.
Exactly, and as you know, appraisals were a fiction for all those years. They were just garbage. Totally. They were complete lies.
Totally.
Or just...
They weren't worth the money, the paper they were written on.
They were less than that. Right. In fact, they were worse than that because paper may cost a penny, and what they caused was huge amounts of problems, including a world crisis, an economic crisis. So it's horrible, and unfortunately, those in the business are not going to be held responsible. It looks like,
right?
Because there's not enough time to clean up this mess. We need to move forward. But either way, that's the situation. So then, as soon as the crisis happened, they started believing that the appraisers were incorrect, and now developers are saying, no, we're not giving you your money back, and I needed to go to the table and negotiate to either get them their money back if they lost their jobs or to get discounts if they hadn't but couldn't get the same mortgage. And that's where the Interstate Land Sales for Disclosure Act came into play.
And what does that act say?
1968. People are buying property across the United States. A federal law comes into play. And what they're saying is that people are buying land, let's say in Oklahoma, and they think they're buying one plot of newly constructed property, a newly constructed development, and they think they're buying one, but they find out that they're supposed to be really right near the lake, and then they find out that they're actually far away and in the desert. So the federal government, the Congress said, how do we make sure that the people buying property get what's being delivered? And it happened. And so you have to in a contract, you have to describe in detail what you're buying. And it has to be in recordable form, meaning that there's a description where you can take your contract, you can take your document and read it, and then actually find exactly what you're buying.
So is it like a legal description?
It's just like a legal description. It's basically a legal description in recordable form that now has to be in the contract of sale, or always should have been in the contract of sale.
So, and this is something I'm not clear on, is that and what I believe the way this works is that the contract has to be registered with the city when the contract is signed. Well, if there's 100 more units, is that
right? Oh well, a little bit.
How does that work?
There's federal law and then there's New York law.
Right.
So the federal law. Under the Interstate Land Sales for Disclosure Act, the federal law requires that you get certain protections, certain documents, and they're mostly forms. And very few developers actually comply with those.
Really?
Yes, very few actually complied at all.
Considering how thick the offering plans are.
And they're different than what's in the offering plan. But many companies, such as Related, who was the defendant in this company, comply with many of the aspects of the Interstate Land Sales for Disclosure Act. And there's many documents and there's protections and there's disclosures. But one of the other things they need to do is the contract has to be in recordable form. And under New York law, it's got to be notarized and it has to have a legal description or a description whereby you're going to know the lot and block or the tax map number that you're going to buy. And they didn't do that, and that's why we were able to win that case.
Really? So the contract doesn't have block and lot in.
Well, it does. Anyone buying a newly constructed unit in America over 100 units is going to have that now.
It's going to have that.
It's not a big deal to comply with the law. It just wasn't being complied with because no one had really reviewed the 1968 statute.
Not being an attorney, one thing I didn't understand was when you register a contract, how can that be perceived as a lien or something against the private? How does this work?
Well, the problem that attorneys
have a hard time getting my arms around that.
Well, see, when a bank, it's all about the lending. You know, whoever controls the money controls the deals. So the lender doesn't want to give a loan if it's not the first lien, meaning that if the person takes out a mortgage and doesn't pay its mortgage, the lender wants to be first up to be able to foreclose on the property and take it back if the person can't pay their mortgage.
Right.
They don't want anybody recording a contract. Now, if someone's recording a contract, meaning that they're telling the world that there is a contract to sale, the lenders don't want that because they want clean title.
I see.
No, it doesn't really get in the way because all they have to do is state, look, it's a contract to sale. This is not how we're doing it, and it's not a big deal. You can still get title insurance. But it's just something that they just never preferred. But the reason that it became relevant is because every contract of sale, the boilerplate language states that you're not allowed to record the contract.
I see.
So by agreeing that you're not going to record the contract, then you can't record it. The lenders know that policy. So things, once they start building newly constructed buildings again, more than 100 units, they're gonna, or if they're buying it now, then they're gonna have to take that line out of the contract out and allow the contract to be recorded, even though no one has an intention of recording the contract.
I see.
You don't have to record it. You just it has to be in recordable form. So you have to present it so it's recordable, but you don't have to record it. So it's not going to change anything.
Interesting. So one of the concerns was that this will sort of kill the new development market. I mean, I'm exaggerating.
No, one of the articles did say that.
Yeah,
and it's ignorance. That's not true.
It's not true.
No. They simply have to attach a legal description to the contract and take in anything that said it's not recordable and notarize it, and they're good to go.
So it's really changing the form or process of this, as opposed to sort of changing the whole industry in terms of the way.
It's a paralegal change. You cross out one line, you add the description, you notarize it, you're good to go.
But the existence of that condition enables the people already sort of in this pipeline to be able to get their deposits back.
Well, it's interesting because it's going to affect very few people.
Really?
People think this is an epidemic. This is the first time this is being stated. This is not an epidemic because most people that purchased newly constructed units at a price where they would want to get out of their contract was in 2007.
Yes.
The statute of limitations for filing an Interstate Land Sales Full Disclosure Act lawsuit is 3 years. So 2007 is a magic number.
Right.
2007 was when we had our highest price.
Our
peak. By 2008, people were buying it at prices they like.
Right.
So it's a 3-year statute of limitations. So although there's tons of cases in my office, it's not an epidemic.
Interesting. So what that means is that this may take care of itself.
It will.
Yeah.
And it's not that many cases. It's unfortunate because almost every developer, except for one, Related, negotiated. Even Related negotiated. But I guess a lot of real estate is respect.
Right.
If someone is a bully and they're treating you with disrespect and they're Related has a press person named Joanna Rosa who was going after me personally, even though she doesn't know me, and bad articles and the things they were saying were really and there was we won't sell you the place if Adam Leitman Bailey's firm is representing you.
I see.
So those kinds of things are really nasty. So hardball. So, but most developers saw the statute. They wanted to close deals, and they liked that we found this law, and they liked our reasoning behind it. It wasn't just finding the law. We had to find how the law would apply in a creative way.
I see.
Even though it says it right there, it's not a difficult find. It should be affirmed on appeal. Most people think it's going to be affirmed on appeal. So it's just that it allowed the developers' attorneys to sit down with their clients and say, Adam has something here. Adam Leitman Bailey, PC has something. We should give them a discount. It's going to allow you to close your deal and sell apartments. Right. This is now the answer to our problem where we can justify giving them a discount and close the units, and you can make some money.
So in theory, what you're doing is you're clearing the cloud through this vehicle. The assumption is that it would stall the market, but the reality is that because this issue had come up, that you're addressing the issue. And it provides more clarity in these transactions.
Right, and that's why there were so many closings even during this chaos. The reason that we were still able to do business, and there were discounts. If you look at the price in the offering plan and what they closed for, there were a lot of discounts.
Yes.
And this statute was a reason that allowed a lot of us to close deals. It really did a great job of allowing us to close deals, and that's what it was used for. And I never intended on going this far. Only one developer decided that they didn't want to play ball, and they actually eventually played ball, but I think they upset some of the bigger fishes by their actions, and that's why now it's affecting the nation, which is unfortunate.
In terms of the appeal process, how long does that typically take?
We're expecting a year before.
A year.
Yeah.
So whether or not it's overturned, the fact that it's on appeal isn't changing the interpretation now, meaning that you won this case and it's being applied.
This is the law in the Second Circuit. This is the law in New York as of today, and this is the first time this question has ever been decided. So a lot of the country is aware of the decision. We've been contacted by several attorneys doing these types of suits in Arizona, Florida, Las Vegas, and they're very excited about the decision.
Wow. Well, that's got to That's got to feel satisfying.
I mean, it's not. I mean, it's satisfying as an attorney.
Yes.
To help people. Number one, it was satisfying to see a need, see a crisis, and be able to help in a small way, even though it's very small. It's also satisfying as an attorney to actually, and with the attorneys at my firm, to actually take something that no one's found before, it's been around for so long, and be able to help people with it, and do it, and do it in the sense where it's not run of the mill. It's not something you do every day. We knew we were taking a risk. We knew it was risky, and our clients believed in us, and we believed in ourselves. And we got really lucky with the result. But it does feel a little bit like Robin Hood.
Right.
Although I know very little about the true history. I did see the movies, a couple of them. But I do feel like we really helped out New York in a way.
What would have been is the downside simply that they would lose their deposit? I mean,
yes, they would lose their deposits and attorney fees. And attorney fees.
Right.
Deposit and attorney fees.
Right. Interesting.
But remember, a lot of people's down payments are the life savings.
Yes.
Real estate's their biggest investment.
Right, and that's what makes this. That's what gave this ruling so much visibility, because that has been a significant issue, right. Especially with one of the trends that we saw during the housing boom was a rise in the percentage of the deposits, meaning that in the 1980s 10% was pretty common. 20%, 25, as high as 25% was not uncommon during this go round. So the stakes are a little bit higher.
Right, but we don't have any clients that didn't get some kind of money back in every case. Right. Everyone got something. Not always what they wanted, but everyone got some money back.
Something back, yeah. Right. So right now, in terms of real estate law, are there any issues that you see as significant problems facing real estate as we go through this sort of really difficult economic period?
Yeah, well, I believe our economic period is, I don't have a crystal ball as when it's going to actually be better, but I do know that we have a nightmare coming up.
Right.
Or we're in a nightmare and it's going to get worse.
Right.
And one of the problems,
in what way?
Well, one of the problems is the inventory.
Right.
Now, this famous person in front of me invented the word shadow inventory,
yes.
And I copied it and used it without giving you any credit. But in order for housing to be affordable and our economy to move, pricing needs to be reasonable.
Yes.
And that's only going to happen after the foreclosures are pushed through.
Right.
Number one. Number two, the shadow inventory, we need to push through the market because eventually it's going to have to come back on.
Yeah, clear
and that
the
means
market.
a price drop. Yeah.
Right. And this brings my sort of a gnawing issue for me, which would be almost humorous if it wasn't so tragic, has been this whole foreclosure robo-signer fiasco where the servicers were simply not doing their proper due diligence and determining that documents were completely filled out before a foreclosure action was taken. And I'm just wondering your thoughts on that and what that
right.
means.
The newspapers have done a pretty good job on it, but I'll fill in what they haven't done. Okay, so there's something called MERS, the
Yes.
Mortgage Electronic Registration System, and people were doing so many deals. There's so many deals happening, and there were so many intricate ways of who's buying it. Because they would take, let's say, 100 mortgages or 1,000 mortgages and tie them into one bow,
right.
and then sell them to investors. So in order to do that in that kind of volume, they needed something, electronic system, to do it faster and efficient. And that was called MERS. So then the problem started, this big problem I was talking about, the basic, the crux of it, the centerpiece of it is MERS. And because of MERS, people, they didn't always know who the owner was. Because MERS didn't have Wells Fargo attached or Bank of America or PNC or Washington Mutual. Some of these are out of business, but right. But they didn't have a name to it. So then they had to figure out, well, who owned it?
Yes.
And sometimes they made mistakes, or they couldn't. When the person defaulted on the money they took out, they didn't actually know who owned it, or they made mistakes. And they hadn't, and that was problem number one. Number two was they hadn't properly registered the ownership. They hadn't done the assignment, whether it be MERS to someone else or one bank to another, or from the investors to the bigger investors. They hadn't done the paperwork. So they were doing the paperwork after the date that the mortgage should have been signed and notarized. So then, therefore, it looks fraudulent because they're doing it. It should have been done on one day.
Cleaning everything up
after, and they couldn't do that. And based on the law, you're supposed to sign it that day.
Right.
So this poses a real problem.
So it's like signing your closing documents like 2 months after you've already
and now they're doing it
house.
years after.
Right.
And it's just a big backlog. So we need the banks to foreclose. They need to move on with it now.
Absolutely.
They need to get their acts together if they have to hire as many people as they need to. They need good attorneys going through it. Because if they don't, then we're going to have prices will be sustained in the short term because there won't be any foreclosures. But until we get the foreclosures pumped out of the system, until we get everything out,
it's a false market.
It's a false market.
Yeah.
It's a fake market, and people don't know how much to spend. And people that are teachers or police officers or making $100 a year can't afford a home in this area.
Right, exactly. Well, what they've got to move forward with foreclosures to clear the market, but it seems like they have two issues now. What they've got, knowing who the owner of the property is, true owner is,
right? But that's easy.
Proving it, and that's,
proving it. I mean, that's easy to know who it is because they do have that down. So the matter is getting your documentation in order, and they can't assume that the judge is going to help them out. They got to make sure that they have everything right, and it's not that difficult.
But one of the things that I don't understand the sort of ramifications. Beyond what I read in the papers is this idea of you have judicial states and non-judicial states, and it's sort of like half the states are one way, half are the other.
I can explain it. So there's 23 states that are judicial. Yeah. But all that means is that a judge is looking over the foreclosures. You can't get a warrant to evict the people in the home and get a money judgment for the amount of the money you took out to borrow unless a judge signs off on it.
In this region is New York.
It's interesting. New York is a judicial state,
right?
Except co-op purchases, foreclosures were not until April 1st. Before April 1st of this year, before April, or maybe it's April 30th. It's April 1st or April 30th. Right. In April, you were allowed to do non-judicial foreclosures for cooperatives, which brings up a whole other issue. But now you have to go to court and have a judge sign off on them. Before April 1st, you didn't. But we are a judicial state.
What about the region like Connecticut and New Jersey? Are they?
I don't know Connecticut, but New Jersey is a judicial state.
Interesting.
Yeah, I'm very limited because I have this theory that I shouldn't do anything where I'm not the best at it.
Right.
Yeah. So I'm very limited in what I know.
I'm exactly the same way. I don't talk about housing markets I don't know. So when
I believe Connecticut is a judicial, but I don't like guessing about anything.
Yeah, no.
In fact, my book, I saw a flaw in my book. My book is 300 pages,
right?
And it's called Finding the Uncommon Deal. And I spent 6 years killing myself on it. Anytime someone would ask a question or I read in the newspaper or something, I would make sure it's in the book.
Right.
So one of the things I did was I realized a weakness because the book's written for the nation.
Yes.
But I couldn't really talk about specifically what's going on in Montana or Connecticut.
Right.
So we created a website, which isn't up yet, where experts from 50 states, and if anyone listening wants to contribute and you're in a state, let us know because we're splitting up, dividing up the nation, and we're giving out territories, and we're going to have experts talk about their state and home buying tips in their state, or real estate brokers in their states, or appraisers in their states on their expertise, so we can really make this a book that's not only because of the new technology we have, the internet.
Right.
We can really make this a book for the nation. And the book's great in itself, and then it gets expanded through insider tips on that part of the nation.
Well, it sounds like I'm always asked, how I manage my time because I push out a lot of content. I have 4 kids and a couple of businesses. But I think I've met my match because you are going 100 miles an hour.
But I mean, you and I have an obligation. I mean, actually, we don't have an obligation. We realize that we are blessed. We are blessed with certain talents that are needed in this economy to make this country a better place. And because of that, I think we have an obligation to use our talents to help people.
Right.
I don't get paid anything for talking to a newspaper or writing an article for a book that I'm not going to make any money on.
Right.
That I spent 6 years and
that seems
countless
to be the common
nights.
refrain with people that write books, right? You share all this knowledge, but at the end of the day, unless you're Stephen King or some other big name, you don't end up making any money.
Well, my book is dedicated to all those people, whose parents and grandparents couldn't teach them what's in the book. I grew up poor. I didn't know this knowledge. I couldn't find the book that could help me. I just wrote the book that I needed when I was buying my first home.
To make it happen.
Yeah.
Well, listen, Adam, this has really been fun. I have a lot more insight on these rulings and what you're all about. I really appreciate your time.
Thank you for having me. It's a pleasure, and it's an honor to be interviewed by you.
Oh, thank you, Adam.
Thank you very much.
That's it for this edition of the Housing Helix podcast. As always, you can send comments and recommend guests to my email address, jmiller@millersamuel.com. This episode and the entire podcast library are available as a free subscription through iTunes and at thehousinghelix.com. So until next time, I'm Jonathan Miller, and thanks for listening to the Housing Helix podcast.